you're entitled to one free photocopy of your medical records if you're pursuing Social Security disability. It's why we try not to order, and we will from time to time, depending on what's going on with the case, but we try to use that closer to the hearing level and tell Social Security to go order the records because they'll pay for it at app and recon. But
welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode.
yeah, I remember having conversations with not just you, but other Social Security judges when I was kind of when I was studying for the bar, doing hearings reporting, where they'd they would turn to me after the hearing and be like, that lawyer did not read the file. You know,
Right.
they couldn't even answer a simple question like, what's the alleged onset date? So,
Pretty rough.
yeah, so it's tough. Okay, let's go on to and I think it goes with kind of number 3 a little bit. You talk about advocating, but number 4 we wrote down good reputation.
Right.
And let's just kind of talk about that, because I do think not only a good reputation within the community of clients or potential clients, which, people look at Google reviews or whatever, referral, but also like within the Social Security Administration, which I know it's hard if you're trying to hire a lawyer to know, unless you know someone that works for Social Security.
Right.
But even then, kind of generally, I think at the hearing level, where it can be really instrumental is the reputation of the lawyer with particular judges.
Yeah. That's very difficult. It's a very important part of advocacy, though, I think. And I remember as a judge, very clearly that there were some lawyers who had very negative reputations, and you could pretty much, anytime they were scheduled for a hearing in front of me, I would pretty much guarantee, A, they hadn't read the file, B, they weren't an advocate for their client. And some of these attorneys are still practicing very actively, but they don't have a very good reputation. And that's important, because when your lawyer speaks, it's important that that judge pay attention to what they're saying and that the judge believes what they're saying. Okay. And I've had cases as a lawyer where I've actually told judges, okay, well, this is the evidence in the case, and I'm waiting on records, and they should be here in the next couple weeks so I can prove what I'm telling you. And the judge will say, you don't have to prove it, Mr. Hyatt. I'll take your word for it, and have gotten benefits for claimants that way. Reputation is really important.
I think it's a fair question to ask, if I'm a claimant, to ask your lawyer, what's your relationship like with this judge? Right? Or do you know this judge?
Right.
And there's new judges coming in and out, and different things happening. And as we grow, our firm grows, we're now more comfortable with, judges outside of the Pacific Northwest. We're getting to know them pretty well. But every once in a while we get a judge we don't know. And so it's sort of like it's like a clean slate, at least that way, reputationally, like, hey,
Yeah.
um, I'm and I love it because you have the advantage of saying, "Oh yeah, I used to be a social security judge, and when I was a judge, I would," but
Yeah.
um, but I do think like you said, from a reputational standpoint, um, it is important if you hire an attorney who does a lot of hearings, especially in a particular hearings office,
Right.
to kind of go to that lawyer and ask him like, "Hey, what's your relationship like with this judge?"
Yeah.
And sometimes they're so bad that like I've seen articles in the news or about different lawyers and different social security judges. Um, but yeah, I mean, that's a fair question to ask your lawyer.
Yeah. I agree.
All right. Let's talk about number 5, resources to help educate the claimant.
Yeah. Okay. Well, that's where you're a real rock star, Peter, because you've got these videos. And most of my clients now, I tell them, have you, or ask them, have you watched any of the videos on the Evans Disability website? Oh, yeah. I've watched them. And, those are great resources for educating clients. And frequently, uh, it will put them a lot more at ease when they go to court. It doesn't have to be a heart attack inducing experience if they know what to expect. And that's that's a real important part of uh, legal practice in this arena.
Yeah, I appreciate you saying that because I like, and I'll put some links to it, but especially at the hearing level,
Yeah.
I know it can be so like, what is a hearing like? And I remember having, I don't know, after doing, 5,000, my 5,000th hearing,
Mhm.
trying to, and not trying, but just, you start to feel like a record player just on repeat, like, oh, this is how it's going to go. And this is what's going to happen.
Mhm.
And, my business partner and my wife said, "You should just record that and, put it out there and see if that would help clients."
Yeah.
And we did a mock hearing so people can see what that's like, and like
Right.
you as a judge and a couple of our lawyers. And then, we do in-house, we have a pre-hearing, conference video that I send, our clients that kinda talks about what to expect. And and then it just kinda grew from there, like, let's do one about how to fill out the, past work history form or the adult function report form, and really trying to serve people that way. And what we found out, and this is what I love about it the most, is that when we did it live, meaning I'm gonna walk you through for the next 30 minutes to an hour of just lecturing you about or giving you, everything and just write it down. A lot of people would not be able to kind of sustain concentration for that long. Where
Right.
with videos, they're saying, "Oh, it's great because I can go back and I don't have to watch it once. It's
Right.
all there, and I can rewind it and fast forward,
Mhm.
watch it
Mhm.
again, and I don't have to call you to make another appointment." And sometimes my appointments get 2 to 3 weeks out just because we get so busy, and so, so yeah, no, I appreciate you saying that. It's been, definitely one thing that, we get a lot of compliments on from our clients. So,
Good. Yeah, it's unusual, and it's a real benefit to the claimants.
number 6, check how your lawyer charges for costs, which we talked about earlier is different than attorney fees. We want to address this?
No, I think you pretty much already covered that, Peter. And
Yeah.
you said that average costs are about $20, and you don't charge for reimbursement if it's less than 100. That's extremely fair, really.
Yeah, I think, yeah, just cost. Be careful. Look at your if you're hiring a lawyer for the first time, look at their fee agreement and ask, or just ask them. Our fee agreement says we can charge for stamps and photocopies and all of that. I leave that in a little bit, uh, generally, and this is just for us.
Sure.
I don't judge other firms. I get it. Costs are high, but generally, kind of what can happen from time to time is and this is the only time I really charge for stamps, is if I meet someone who says, look, I don't want a CD, I don't want a USB, I don't want an email. I want you to mail me my file, and it has to be paper. So now I have to print out 1,000. That's just the medical records. There's other parts of the file that are not medical records. So let's call it 1,500 pages of paper.
Yeah.
And then I won't even measure on the scale because it's so heavy. Then I have to go to the post office or says, have it and then all of a sudden, just to mail it, I have to pay like some, exuberant stamp cost or buy the office and pick it up. And I just like 3 trees, right? So if a client is not willing to take it like a USB, which I will buy the USB for $1 and mail it, and they only want paper, which is fine, they're entitled to a copy of their file, then that's where I will charge them for the stamps.
Sure.
But a lot of lawyers do charge, and all of a sudden they, even if the client loses, they're getting, I had clients call me like, oh, I got a $272 bill from this firm. And I'm like, well, you have to pay that because you signed an agreement saying you would pay for that.
Well, and I think ethically, there is a prohibition ethically for an attorney to have an investment in a case. So if I'm going to court for a client and they owe me a bunch of money because of costs and so forth, I don't want to have an economic investment, because then I'm going to say, I mean, that rule is basically for much more expensive cases like medical malpractice, where costs end up being $150,000. That's a real economic investment of the lawyer in that result. And
right.
So I think it's important that you keep it in your fee agreement that you can charge for costs, but I think it's also good that you generally don't. So
yeah, we don't.
Yeah.
All right, and I think moving on, we are down to number 7, our last one. Make sure the file is complete before the hearing is what we wrote down.
Yeah.
Take that into consideration when hiring a lawyer. How do they manage their hearing files?
Well, yeah, the rules have changed since I was on the bench, and now they have what's called the 5-day rule. So if for some reason or another, the record is not absolutely complete, up to date, and it's not unusual for clients to be continuing to get medical treatment all the way up to the day of hearing. And so if that's the case, we can submit a 5-day letter, which means we can ask the judge to keep the record open for a couple of weeks after the hearing so we can get these additional records in to make the file absolutely complete. And that works really well. But I do have to say, Peter, that I don't know how many hundreds of cases I've done for your firm in the last few years. I would say maybe 2 times I've gone to court and the record wasn't complete, other than the 5-day, getting the last few weeks of medical records. The records generally, medical files are generally very thorough and very up to date, and the judges appreciate that and recognize your firm for that. They've been very complimentary about that.
Well, I appreciate you saying that. It is a lot of work. And to get, so just a little bit of background, at the application level and the reconsideration level, Social Security orders medical records for your case, for a claimant's case.
Right.
At the hearing level, they typically do not order any more. Social Security does not order any medical records unless you specially request it of the judge, which from time to time we do that too. We'll subpoena, please go subpoena these records because the medical provider's not giving it to us.
Mm-hmm.
This is where costs come in too. We just talked about costs, is that once we request the medical records for a client, they typically will send us a bill saying, the first 10 pages cost you $10 and every page after that costs you, 25 cents.
Yeah.
And so it's like, okay, we get hit with a photocopy bill, and a lot of states that we represent people in have at the state level have a law that says you're entitled to one free photocopy of your medical records if you're pursuing Social Security disability. It's why we try not to order, and we will from time to time, depending on what's going on with the case, but we try to use that closer to the hearing level and tell Social Security to go order the records because they'll pay for it at app and recon. But sometimes we meet folks as like, oh, I've been to 4 different emergency rooms, like this hospital, this hospital, this hospital. I get treatment records, and it is the organization of it is probably the most difficult part when you kind of do it at scale. But I do really appreciate you saying that.
Yeah.
It is organizational. I don't want to use the word nightmare, but it is definitely you got to stay well organized in order to do it. So, and we try to do we're not always perfect. I don't think any law firm is, and you're dealing with, medical providers. So anyway,
Yeah.
I'm grateful that you said that. I can't think of anything else off the top of my head. I'm sure people might say some stuff in comments. Oh, you should consider this or think about that. I mean, I think one thing that we run into from time to time is, oh, I like so and so, but I didn't like the other lawyer, and that happens at our firm, right? Because different personalities, different ways to communicate, and so and and it just is what it is, So there's that. And I think too, from our perspective, is laying out expectations. Like, here's what you can expect from us. What do you want from your lawyer? And then can we meet those expectations?
Yeah.
Because just as I think we're a great fit for a lot of people based off of, who we are and what we've done in our experience, we're not always a great fit for everyone, right? If you want that, like, I want to talk to my lawyer every day, literally every day, or once a week even.
Yeah.
That's probably not going to be a good fit for us, right?
Yeah. Yeah.
And I accept that. And I don't begrudge a person who wants to talk to their lawyer. I think in our industry, you'll have a hard time finding a lawyer that's willing to talk to you once a week, to be fair. When a case goes on for, on average, 2.5 to 3 years, you're going to be hard pressed to find a lawyer that's going to meet that expectation.
Yeah.
So anyway, as always, with that, thank you. I appreciate your time today and your wisdom and knowledge. Anything else that we haven't talked about?
I don't think so. I think you pretty much got it covered, but I'm sure after we're off the screen, other things will pop in my head, but I'll write a little note.
We can only make a part 2 video.